I have come here to chew bubblegum and kick ass. And I'm all out of bubblegum.
This is the Virtual Real Estate Investor Podcast with Vincent Polisi. Buckle your seatbelt and prepare to learn how to legally make six figures investing in real estate with no money, no credit check, and nothing but a computer and internet connection. Learn how you too can begin generating buyers and sellers for free today. And why you're only 2 calls away from making a $10,000 or more payday while never leaving the comfort of your home. And now, your host, the virtual real estate investor, Vincent Polisi.
How many of you have actually personally done a lease option before? If you've done one, leave a comment that you've actually done a lease option, whether for yourself or for an investment deal. Okay, if you don't, let me know. I guess it'll be interesting to see exactly how many people have done these things. You guys are obviously on here because you want to know what the lies are, but let's go ahead and go through this. First, as a background, what is a lease option? Lease option is essentially 2 agreements. Okay, for the purpose of this webinar and Facebook Live and podcast, what we're talking about here are lease options on single-family residential. I'm not referring to master lease options on multifamily or commercial, whatever. I'm talking about strictly the vanilla, what you see on Facebook and the Facebook groups every single day, this vanilla lease option deal. They just lauded as being the epitome of perfection on how to make money in real estate investing. Okay, and there's a lot that most of you probably do not know that we're going to cover here today that hopefully will be beneficial to you guys so that you guys don't run into the pitfalls that I'm about to show you that are actually real and out there and that I have personally witnessed in real time. So we have 2 agreements. We have a lease agreement and we have an option agreement. Lease agreement is a standard rental agreement. Nothing fancy about it. It's a normal rental agreement. Option agreement is an option to purchase the details, the cost of the option, because there's going to be an option fee, the term of the option. Options always have a term. How long is the option good for? In other words, how long is that particular seller taking the property off of the market for you to give you the opportunity to exercise the option and actually purchase the property. And it also will include the price of the property once the option is exercised. Okay? Very, very simple. Now, here's a real life example. This is when I lived in Alpharetta. My next door neighbor, multi-millionaire real estate investor in his 60s, had been in real estate investing for more than 30 years. Here's a real life deal that he did on a new construction townhouse that he and a partner had bought in downtown Atlanta by the stadium. And when the market started to turn, he could not unload it. So my advice to him at that time was, hey, why don't you just do a lease option? Okay, this goes back to 2006, okay, or maybe 2007. At that time, and we'll get into my background story here. I had personally done lease options for myself. I understand the mechanics of exactly how they work. Had been in real estate for, let's see, at that time, roughly 20 years. Nothing magnificent about lease option. But what he did was they couldn't sell this property. So he had some guys that wanted to buy it, but they couldn't get their financing together. So he did the traditional vanilla. He took my advice, did the traditional vanilla lease option deal, and the optionees basically gave him $65,000 to option the $650,000 property for 6 months. Literally, it was a 6-month option for $65,000, which to me is absolutely insane. But he got it. And what he said to me at that time was, hey, I don't care if they exercise the option or not. I got $65,000, right? And that's the typical investor logic that, hey, I got $65,000. It's not refundable if they don't exercise. Get them out, and we'll do a turnover, and I'll either do another lease option or I'll sell it to somebody else. Okay, that's typically how people think when they come into a lease option deal. All right. So, as a side note, as far as we're talking about options, in case you guys are not aware of this, option fees are not taxable until the option is exercised or abandoned. So it's going to be like one of the closest things you guys can get to, an interest-free loan or a tax-free loan for that period of time, because you don't have to pay taxes on it. So if you have a multi-year option, you don't have to recognize that revenue as income until that option is exercised by the tenant or the optionee, or it's abandoned. Okay, and form of abandonment means they just don't exercise it during the term. Okay, so a little side note there. Now, who are the entities on the contracts? This is something I see get thrown around every single day, and people do not understand what the importance of literally every word in a contract is. Okay, until you get into court. Unfortunately, you don't realize the importance of all the words. People think, oh, you're just being nitpicky, or you're just being, it's all semantics, or it doesn't really matter. Well, let me tell you something. When you get into court in front of the judge, everything matters, especially the language in contracts. So the entities on a lease agreement, the lease part of the lease option, are a landlord and a tenant. Okay, that's it. Nothing else. Landlord and tenant. Entities on an option agreement are optionor and optionee. Okay, that's it. Nothing else. There is no other entity on this agreement. Now, notice there is no entity called a tenant buyer because there is no such thing as a tenant buyer. This is a very, very dangerous term and something you do not want on your contracts for reasons I'm going to explain to you here in just a second. Okay, but on the lease, you have a landlord and tenant, and on the option, you have an optionor and an optionee. That is it, and that's the only entities you ever want mentioned on the agreements. Okay, there are only two, again, for qualification, we're talking about single-family residential here. I'm not talking about master leases on apartment buildings or anything. There are only two legitimate times to do a lease option, okay? Like legit, these are the only two times that you would want to do these on single-family residential. And that's where the tenant legitimately wants to try before they buy, okay? Somebody may be moving from another location. They don't know the neighborhood. They don't know if they like the house. They absolutely want to check it out and make sure it's what they're looking for before they commit to a purchase. That is a legitimate deal. Okay. Also, investor deals, right? In this scenario here, as an example, in Florida, especially when the market was on fire, if you go back to 2003, 2004, what investors were doing is they were doing lease option deals on investment properties with an ability to sublet and turning them into vacation rentals. And what the objective was the purpose of their option was they didn't want to commit to purchasing a multi-million-dollar house or $1 million plus house on the water until they saw that the market was going to continue to appreciate. And then at that point in time, so basically they come in and say $1 million on a lease option deal. They rent it out as a vacation rental or as a straight up rental for a year or two. Now all of a sudden it's worth $1.2 million. Well, now they want to exercise their option at $1 million because they can scoop an easy $200,000. Okay, that is another legitimate time to do a lease option, right? What is not a legitimate time is trying to cram every deal that comes across your desk into a lease option, right? Now, let me give you my personal history with lease options as my personal primary residence, so you guys understand that I have done this on my own for residences in, let's see, on 3 separate occasions. Okay, on the last occasion, this would explain to you one of the benefits of a lease option, was on a $2.5 million house in a master planned golf course, resort, for lack of a better term, resort community down in Sarasota called Lakewood Ranch. Okay, he's got golf courses, guard gates at the guard gates, all the bells and whistles, whatever. $2.5 million house. I was paying $12,000 a month for under the lease. I also had an option to purchase that particular property. This was in 2006. What happened at the end of 2006? The media gets it all wrong. They say it was 2008 was the housing crash and all that stuff. It actually started at the very end of 2006 when Wall Street suddenly upended the mortgage markets by refusing to honor their commitments on pricing. And so basically you had multi-billion-dollar corporations going out of business overnight because they couldn't get the funding that they needed to get the money they had off of their warehouse lines. Okay, so from there, everybody knows 2007, 2008. Prior to my option expiring, okay, and we're talking about this is a $2.5 million option. Prior to the option expiring, based on the housing collapse, the property was valued at $960,000. Okay, it was a new construction home. I was the first person that had lived in it. It was a builder's model home. And by the time the train wreck known as 2008 was done, it went from $2.5 million to $960,000. So Benefit, I didn't have to exercise the option, did not have to stay there, did not have to pay $2.5 million that I couldn't have paid anyway on a $960,000 house because I wouldn't be able to get financing, right? So that's my personal story. I personally lived in them as lease options, so I understand this. Now, one of the biggest falsehoods that is out there is that lease options are the fastest and easiest way to make money in real estate. And while that can be true at times, it's used generally in ways that it should not be to seduce people into buying these lease option courses. Okay, I see Bill Walson's on here, and you weren't on here when I gave the caveat before. I'm not talking about master leases and apartment buildings and all that stuff. I'm talking about just the single-family residential, the vanilla deal that's out there. And the reason why is common sense. So when you're doing, if you've never actively done lease options, which I've done them on a retail, if you want to call it retail basis, to tenants and optionors, for tenants and sellers and blah, 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 whatever. Done tons of them, okay? That's how I started Virtual Real Estate Investor back in 2007, was doing lease options in the same way that many of you are doing them right now. And I'm going to show you some of the lessons that I learned along the way and why we're having this conversation today. So when you're talking to a potential tenant, typically the way these things are marketed is they're marketed as some type of rent to own, right? Which is a mistake, and we'll cover that here in a second. What happens is this: you're having to typically fight with people who want to purchase a property but can't. Sometimes it's credit, sometimes it's the inability to document income, whatever. They can't get a mortgage for whatever reason. They really actually want to buy. And so what investors do is they market as rent to own, which is a monumental mistake. And then they slap people in lease option deals. And as a result, one of the things that you have to deal with is the option fee, right? Because the average person that wants to buy a home wants equity, right? They want to know that their option fee is going to somehow be credited against the purchase price of the property. What they don't want to do is pay you 10, 15, 20, 25 grand for an option fee to then not have that credited against the purchase price. Okay. And there's all kinds of dangers inherent in rent credits, which we'll cover in a second, right? So from my personal perspective and experience, it's much easier to just use owner financing, where the buyer comes in, they actually own the property from the onset, okay? And the money that they're paying for a down payment is instant equity against their purchase price, right? Because remember, the intent here, what everybody really wants is a sale, okay? That's what they're really looking for. They really want a sale. They would be buying if they could, and you know that because you lured them in on a rent-to-own marketing campaign. But instead, they get slapped into a lease option, or you try to force them into a lease option deal. And the typical blowback or pushback that you're going to get is about the credit for the option fee, right? Because they want to be owners, not renters, okay? So here are the dangers of lease options. 99.99999% of lease options on single-family residential are structured as disguised sales. I have not seen one person in 6 years of coaching people on Facebook, whatever, ever present to me a lease option contract that was not let me rephrase that, not structured as a disguised sale. Every single one of them that I've ever seen, that ever been presented to me from every other course imaginable, they've all been structured incorrectly through a variety of different methodologies that I'm going to show you right now. So what is a disguised sale? A disguised sale means that, once again, the intent of the buyer, the tenant, was a purchase and sale. The intent of you, the investor, was actually a purchase and sale. And for a couple of reasons here that you're going to find out, it was not structured as an actual sale, okay, based on the IRS's installment sales contract guidelines, owner financing, land contracts, whatever. You structured it as a lease option because you perceive there are benefits to that and risk mitigation, but you didn't really understand the spider web that you were putting your finger into, okay? A disguised sale is created regardless of the fact that the documents are a lease and option agreement. And this is important to understand. It does not matter that you did a lease agreement and an option agreement. When a disguised sale is created, because the intent of the parties is actually a sale, okay? Doesn't matter if that's what you are trying to base your entire defense litigation on, the fact that it's a lease and an option agreement. Yeah, I'll show you exactly how that works out in court in front of the judge, okay? So bad examples of things not to do. Marketing the property as rent to own. You don't want to do that because you're clarifying up front that the intent is a sale. Okay, it's not a rental, right? It's not rent with an option to purchase. Blah blah blah. It's rent to own. That's the intent. That's what the buyer wants. Buyer wants to buy, but you use a lease option to avoid the requirement of a foreclosure if they default. This is one of the reasons why they typically are done this way. Okay, a lot of people they think they're going to avoid foreclosure in the event of default. But you have to keep one thing in mind: intent is everything. And I'm going to give you real life examples here of exactly how these things go down. Okay. So lease option pitfalls, using terms like tenant, buyer, or seller. These entities do not exist on a lease option contract. Okay, don't use them. Do not put them on there, because what you're doing is you are broadcasting what your intent is. Your intent is a sale, and you do not want to do that. Okay. Next thing up, requiring tenants to handle maintenance and repairs. Some people want to argue this thing till the cows come home in different states or whatever. And I'm just telling you from personal experience, once you get in front of the judge and the judge sees that you're trying to push off maintenance and repair expense on a tenant, and those are owner expenses, those are investor expenses, not a tenant expense, you're almost always going to side in favor of the tenant, okay? Because the judge knows what you're trying to do, right? Referencing either agreement in the other agreement. Okay, what I mean by this is they're two standalone agreements that should never reference each other. In other words, the lease is a lease agreement in and of itself, by itself, and does not reference the option agreement. Option agreement is an option agreement and does not reference the lease agreement, nor does it reference tenant buyers or anything like that. Okay, never have them talk about the other one. I see these things commingled all the time where the documents will then reference the other document. Now you're just opening up a can of worms for disguised sale, especially when you are doing the next thing, which is providing rent credits. Now, I will tell you this, again, when I first got going on doing lease options as a moneymaker back in 2007, we were doing all kinds of crazy stuff, okay? We were doing 100% rent credits because we could get away with it at that point in time. All right. So think about this for a second. What we were able to do, and the lenders, Fannie Mae, Freddie Mac, whatever, would, guys, I'm sorry. This, for those of you, that thing that keeps going off is our private Slack channel for the medical commodities business, and those are inbound text messages from people trying to sell us products. So I can figure out which phone it's on. I'll turn that off. So we'll stop banging. But they're being handled by my assistants and JVPs. Let me turn this phone off. Sorry about that. So, all right, providing rent credits. We were able to provide 100% rent credits, which means that at that time, as an example, so our target minimum price point was $300,000 in markets like Atlanta, which would create a payment of about $2,000 a month. So what we were able to do effectively was provide tenants up to 100% of their monthly rental payment as a credit against the purchase price. And basically, the strategy here is what some people call it forced appreciation or whatever it is. You have a when you do a lease option deal with someone, you have what's called the option price or the strike price. Okay, and so in other words, if you were, let me see if I can make this simple. If you were acquiring the property on a lease option with an ability to sublet that property to somebody else on a lease option deal, then you have an option price and a strike price. Let's just say that's $300,000. Well, you want to make money on the backside, and you want to be able to, and or additional money on the front side through the option fee. But you also want to be able to give the tenant rent credits, which is going to be essentially principal balance reduction. Well, you're not going to sell the $300,000 property that you optioned at $300,000. You're going to sell it at $325,000 or $350,000 or whatever number it is that comes up. Okay. And then you can apply rent credits. So from a tenant's perspective or from the optionee's perspective, it would appear as though they are getting a principal balance reduction against each payment. And while it's legal, or used to be, I mean, it still is technically, but it's problematic in court because essentially what you're doing is you're providing the equivalent of principal balance reduction, and you would not be doing that normally unless the intent is a sale. So that's why we stopped doing that back in 2008 once I found out all the stuff I'm about to show you. Okay. At that time, we could do 100%. Fannie Mae would take it. So if somebody they were there on the property for 12 months and their payment was $2,000 a month, and we gave them a credit for $2,000 a month, they got a $24,000 reduction off the purchase price, right? And Fannie Mae would fund it. They will not do it at those amounts anymore. I don't know if anybody knows exactly what the percentages they allow now. I'm not even sure what it is, to be honest with you, because I don't mess with rent credits. But like I said, it does become problematic in court because it looks like a sale. And then this is like, I saw this one in Jonathan's Sub2 group the other day. Somebody was talking about, and these are things you don't want to say, oh, I'm going to sell it on a lease option, and I'm going to have, it's a fixer-upper, and I'm going to have the tenants do the capital improvements to the property. This is absolute disaster waiting to happen. I've never once in 30 years ever seen this work out personally, okay? And I've seen it time and time and time again. Typically what ends up happening is when there are capital improvements that need, which phone is, oh, there it is. Sorry, guys, I got multiple phones here. Typically, what ends up happening is you got a fixer-upper. Obviously, you don't want to pay for the rehabilitation or whatever the capital improvements are, okay? And you don't want to have to pay for it out of the option fee because you want to scoop all the option fee and have it go into HIP National. Then what people will try to do is they'll try to put off the capital improvements to the property, whatever the fixer-upper thing is, onto the tenant. And this is just disaster waiting to happen all the way around. Number one, now you've got a tenant putting money into a property, which can result in mechanics liens. No, thank you. And also tenants, why would a tenant be doing fixer-upper stuff on a property? People, oh, well, sweat equity. Well, where does equity come from? You don't have equity on a lease or an option. You have equity on a sale, right? You have equity in a property that you own, right? That's the whole purpose. And so once again, you're broadcasting the fact that the intent is an actual sale. That's why the person is doing the capital improvements as opposed to the whoever it is, the owner, the seller, the investor, whatever it is. Now, the flip side of this thing is here's the way it normally works out. When capital improvements are required, and I'm not saying that there's nobody that's ever had a deal that worked out perfectly when they did this, because there are many people who claim that they have. I've just never personally experienced it, nor have I ever seen an actual deal go through this way. But typically, what ends up happening is it's normally the kitchen. It's almost always the kitchen. Okay, the people get in the property, and the husband starts ripping the kitchen out, and then he runs out of money and can't finish it. And the wife's not happy, doesn't have her cabinets, doesn't have everything set up, can't cook. And it's only a matter of time before they stop making payments and leave in the middle of the night. Okay, I'm just telling you, I've seen it time and time and time and time again. So you never want to have a tenant do capital improvements to the property. Okay, if you're going to have capital improvements done, then you need to get the funding from them in some other way so that you can be the one that pays for it, and they don't have any claim of any type of mechanics lien or equitable interest or anything else. So why are these pitfalls? It's called equitable interest conveyance. Okay. Equitable interest conveyance. What is equitable interest? It's also called equitable title. You've got to understand the two types. There's actually three types of title, but for the purpose of this, I'll cover all three of them for you. All right, two types of title. You have what it's called legal title, and this means that you have the deed, okay? Which on a lot of the deals that I do, I don't have the deed. I don't care about the deed because let me rephrase that. Depending on deal type, if it's a short sale or something like that, yes, I want the deed. But on a standard owner finance deal where I'm buying the property on contract for somebody, I don't care about the deed because the deed does what for me if there's a security instrument in place in front of it? Nothing. Okay. All it does, the only thing that a deed does on an owner finance deal is it enables a buyer to stay in a property longer because they have to be foreclosed before they can be evicted to get the deed back because they've got legal title to the property. That is the only material benefit because there is a security instrument of some type, okay, in front of this, which would be the mortgage that you have with the seller, the mortgage that he has with somebody else. There's going to be another security instrument in place that would not help you with it. I mean, the only thing you do is pay it off, okay, which you have the ability to do anyway. All I personally want is control, okay? I don't care about deeds on most transactions. But that's legal title. Now, next up is equitable title. This means that you have what's called a bundle of rights associated with the property. While we're covering this, let's go ahead and cover this. There is no such thing as a paper document in real estate investing called title that transfers ownership of a property. That's vehicles that have a title. They have a paper title. Properties do not have a paper title, okay? All the title is, you'll get a chain of title from the title company, and it is on a piece of paper, but it does not convey equitable interest. It's showing you anybody that has filed a claim of equity against that property. That could be the county tax assessor, that could be the IRS, it could be obviously your mortgage company, could be some plumber you didn't pay, could be any of a number of different things that would give somebody equitable title to the property, right? When you are doing lease option deals and or you're doing owner finance deals, the disguised sale lease option deals, which most of them are, they convey equitable title, whether that was your intent or not. Okay, and it's a very dangerous thing once you end up in court. And I'm going to show you some real life examples here in just a second. Now, the third type of title, which most of you probably never heard of, is a allodial title, which is the actual ownership of the property, which you don't get with legal title or equitable title. But allodial title you get, and you typically have to do that via what's called a land patent, which is very difficult. They try to prevent people from doing that because then they can't tax you, and they don't. And you actually have ownership, and you don't take title as a tenant. You actually take title as an owner. Okay, actually, there is no real title. It's you own the property. It's totally different. If you guys don't understand what I'm talking about, and without getting off on all the tinfoil hat stuff, if you go back 150 years ago, the Wild Wild West days and all that kind of stuff, all the cities had a land office. And what you would do when you wanted to go buy property was you would go to the land office and you would pay for it, and they would give you the deed to the property. And you own the property, and that's what it was. And the deeds were passed down from one to the next to the next. Well, they converted that to, well, we don't get ownership of land anymore. What we have now is we have interest in real estate. Two entirely different things, okay? Totally different things. And allodial title will give you actual ownership, where legal title and equitable title do not. That's why you take, now listen to this very carefully so you guys can understand what I'm talking about. That's why you take, good God, which phone is that? You take title as what? A tenant. You buy it. Like, people want to argue with me all the time. Oh, if I buy the property, I own it. Really? Well, how'd you take title? Took title as a tenant of some type. You took title as a tenant with joint tenant with a right of survivorship. Took title as tenants in common. You did not take title as an owner. Okay? Got that? So these are the two types of title. Anyway, you can have legal title and equitable title. You can have both. Okay? So if I have the deed, almost all the time, except for one time that Bill wisely shared with me, there's only one time that we can think of where you would have legal title but not equitable title. Okay, or legal title but not equitable title, and that's in the event of a oh my God, it's on the tip of my tongue. I can see it. I'll come back to it in a second. I think about it. But anyway, for the purposes of what we're talking about, each property that's out there, you have legal title and you have equitable title. All right. If you have the deed, you're almost always going to have both of those. And equitable title basically is a bundle of rights associated with the property. All right. So you can have equitable title with no legal title. And a couple of examples of that would be doing a contract for deed where they don't have the deed, they don't have legal title, but they have equitable title. They have control. They have a bundle of rights associated with the property. Okay. And so we're going to get to how this applies to actual lease options here in just a second. All right. Once you have committed any of these pitfalls, you have conveyed equitable title to the tenant. Okay. Whether you think you have or not. Let me show you how it works out. The big question is, why does that matter? Because once you've conveyed equitable title, the tenant can default and use the equitable interest argument in court to force a foreclosure before you can evict. Okay. So here you are, happy little investor. You bought somebody's course on the internet, on Facebook or whatever, and you think that you've mitigated risk, you've gotten rid of all the maintenance and repairs, right? You provided this guy rent credits, so he's getting a good deal, blah, 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 blah. And what you really did was created a disguised sale. And now when something comes up, the tenant, if they have knowledge or if they lawyer up, can argue the equitable interest argument. And now the magistrate judge, who would normally file the dispossessory warrant, cannot hear the case for an eviction because he cannot rule on claims of equity. It has to go to the superior court at that point. Okay, this is real life stuff on actual lease option deals that they don't tell you about in these stupid courses. Okay, but it gets even worse. How does it get worse? 2 words. It's called Dodd-Frank, right? I know what you're thinking, but Vincent, Dodd-Frank doesn't apply to lease options. Au contraire, mon frere. You may be told not, but let me show you how it actually works out and plays out in the real world on a real deal. Okay? Nope, I got these slides out of order. Hang on. So here is a real life deal. All right, let me get back up here. Real life deal. I contracted on a $1 million home in San Diego 2 years ago. Okay, seller of the property lived in Hawaii, and he did the standard vanilla lease option deal, shilled by all these self-proclaimed REI gurus. So the exact same contracts that I would venture a guess that 100% of you are using, other than Bill. And here's what happened. At the time I contracted on the property, the tenant optionee, notice I didn't say tenant buyer, had lived in the home for 7 years. He lived in the home 5 years and paid perfectly, but then he lost his job, got divorced, and stopped paying. This is year 5 of 7. Landlord, the seller, the guy that I contracted with, files for eviction. Guess what? Tenant optionee lawyers up. He doesn't have any money to pay the rent, but guess what? He can pay the attorney. All right? You'll see this time and time and time again. You're like, why don't you just pay the rent if you can afford an attorney? But that's not what they do. Okay? Well, the attorney totally decimated the lease option contract in court for all of the pitfalls I previously stated, because he had committed every error that you could commit. Okay? And here's how it ended. Now, you guys need to pay attention, because they're not going to teach you this stuff. I don't want to tell you about how things actually work in the real world when they want to sell you a course so you can make money. So the landlord, the seller that I contracted with, on a contract for deed, by the way, not a lease option, got to pay for the tenant to live in the home for 2 years. Okay, so meanwhile, he's eating mortgage payments on a house, and the guy's living there for 2 years for free. He got to pay the tenant's attorney's fees. He got to pay his own attorney's fees, okay, during 24 months of litigation, which I can tell you from personal experience, it ain't cheap, because after you get through that initial retainer, you start whacking away at 10 to 15 grand a month. Okay, so it's not a cheap exercise to have an ongoing litigation, especially for any length of period of time. That's why most cases settle, because people get tired of feeding the lawyers. Okay, he also got to pay a settlement to the tenant. Now, listen to this is in California. Got to pay a settlement to the tenant to avoid losing the house altogether, and to get the tenant to vacate the premises before we could put a buyer in the property. Okay. When I contracted on the house, the guy was still in there. I contracted on it with a seller leaseback, so guy's still living in the property while he's still getting all this crap worked out. Okay. Why? 2 reasons. Number one, improperly structured lease option contract and deal structure. And number 2, one attorney who knew the law and invoked the equitable interest argument and Dodd-Frank. Because now, guess what we got? We got a disguised sale, right? We have an actual sale. How and why did it apply? It was just a lease option, not an owner finance deal, right? Right? Wrong. Here's what happens. Once the attorney established equitable interest and a disguised sale, it became a de facto owner finance deal. And that was his argument. And boom, Dodd-Frank now has jurisdiction. You guys aren't aware of this in the Dodd-Frank language unless they've updated it, because I haven't reread all the new updates, but unless they've updated it. The whatever they call him, the czar that handles the CPFB can illegally, under the Constitution and everything, but legally now, the way they've made it, take the property from you if you violate Dodd-Frank. Okay, and that's exactly the direction they were headed in court, and that's why he paid to settle, to get the guy out of the property after going through the process of trying to evict and then foreclose, and still couldn't get him out. Okay, so here. Let me go back. I'm going to show you another real deal. Okay, that this is another one that I personally. Where's that slide? That I personally witnessed. Okay, this is my next door neighbor in Alpharetta. Once again, guys in his 60s, knows, multi-millionaire, knows real estate backwards, forwards, commercial investor, everything, you name it. Has a partner who's the #1 realtor in Alpharetta. at the time, and they were doing joint venture deals on properties that they were then either flipping and I'm talking about high end stuff. I'm not talking about fix and flip. We're talking about no fix needed on a golf course in a gated community, the whole 9 yards. So the investor and the realtor do a joint venture. The realtor handles all of the contracts. Okay, she's the standard Georgia Association of Realtors contract for the lease and the option agreement. And so you would think, okay, well, it's a realtor, number one, and she uses state contracts, number two, so that should be no problem on a lease option deal getting the tenant out of the property if they default, right? Wrong. That's not what happened. What ended up happening is the guy paid the option fee, got in the property, and it was the first payment default. For those of you who have not been in mortgage lending, it's everyone's nightmare, and the mortgage business is what they call a first payment default. So it should be. It's every investor's nightmare too. And so he did it with the intent. Now the guy knew what he was doing. All right, he was somebody like me who understands what the law is, and he had the ill intent of living in the house for a very long period of time for free while playing the paper shuffle with the Fulton County Courthouse. Okay, and that's exactly what he ended up doing. As a result, he ended up being in the house 18 months without paying. And this is with a professional investor and a realtor as the landlord and optionors. Okay, so by the time they were done, they had to eat payments for 18 months, and then they got a destroyed house back where they couldn't. They now had to put more capital into the property to get it back so they could unload the damn thing. That is a real life deal on a lease option. So you got to understand how these things need to be structured if you're going to, get into doing lease options. Let me get to the next slide. Yeah, okay. This is one of the dumbest things I see on Facebook. I see a lot of stupid things on Facebook, but this is one of those dumbest things people say all the time. Well, I'll just sell it on a lease option. You can't sell it on a lease option, okay? What you're doing when you use this type of terminology is, once again, you're broadcasting what the actual intent is. The intent here is a sale, because I'm going to sell it, quote unquote, on a lease option. Why am I doing it on a lease option? Because I want to try to avoid foreclosure, and I want to dump the maintenance and repair expenses on the tenant, and all of these wonderful things that we covered earlier. Just don't, okay? Now, these are what I would classify as the top 7 lease option lies that are told and sold out there. Lease options are the fastest and easiest way to make money in real estate investing. The caveat here is they can be done properly in the right circumstances. Yes, you can do a lease option just like an owner finance deal, start to finish, starting with nothing. You can find tenant and landlord in the same day. You can find, or let me rephrase that. You can find tenant and landlord in the same day and do a deal same day and make money same day and have a wire in your account same day, started from nothing. I have done that many times, okay, on lease options as well as owner finance deals. So they can be, but just because it glitters does not mean make it gold. So be very, very careful when utilizing the strategy, that you understand what you're doing and the intent of all parties is well defined as to what you're doing and why. Okay, if you're marketing rent to own, I would personally stop that. I stopped doing it years ago. I don't want anything rent to own, which I understand. It's the name of the website is Owner Finance It. Okay, boom. Everybody knows what we're doing, right? There's no question about exactly what our intent is. Okay, lease options have less risk than owner finance deals. This is not true. I don't know, and for all the reasons that I just went over here with you just a few minutes ago. Okay, it doesn't mean that on an owner finance deal you don't have to foreclose first before you can evict. You don't have to on land trusts, but on a owner, like a contract for deed or land contract or something like that, you're going to have to foreclose first before you evict on those types of scenarios. So if you're going to run that risk anyway, why not just do the owner finance deal up front instead of the lease option deal anyway? All right. All right, another lease option. You can have the tenant handle maintenance and repairs. Okay. Well, technically on paper you can, and I have done it. We stopped doing it, all this stuff in 2008, after witnessing a couple of these things go upside down with other investors for all the stuff we're talking about here, other than Dodd-Frank, because Dodd-Frank wasn't out yet. You can have them handle maintenance and repairs, but it is very ill-advised, okay, because those are owner expenses, okay, owner responsibilities, not tenants. Tenants don't handle maintenance and repairs, or they can't. You can, depending on what state you're in. I think Florida. I forgot. I looked this up a couple of weeks ago. See, I think it's $300. I think, or that you can offset for a tenant in a property. They can handle the first $300 or something, and maybe $100. I forget. But at any rate, you don't want a tenant handling maintenance and repairs for a lot of reasons. Number one, obviously you want to get rid of the expense. I get that. And if you want to get rid of the expense, you can get rid of it totally on an owner finance contract, okay? Because then they're the owner, and of course it's their responsibility, and they have to do it under the IRS installment sales contract guidelines for them to be able to deduct the mortgage interest and property tax deduction, okay? Rent credits can be used to refund, basically in quotes here, or credit the option fee. While technically, yes, they can, again, you're broadcasting a disguised sale and what the actual intent is. I mean, let me put it like this. You can put anything you want to on paper, okay? Does that mean it's going to hold up in court? No. Does that make it legal? No. Does it matter if an attorney put it together? No, it doesn't, okay? Because they're not providing you an insurance policy against them not knowing what the law is, okay? What's going to happen is you end up in court, and then you got to deal with all this stuff that they're not going to tell you up front, okay? So I wouldn't offer rent credits personally on an option fee, because on an option, the easy way to explain it is they're paying for the option to purchase the property. Seller has to, actually technically the optionor has to take the property off the market for a certain period of time, which means he's losing marketing time, losing time value of money from not having the sale today, and those are real tangibles that he's getting paid for via the option fee. It's a fee, okay? Nowhere does it say option down payment. It's an option fee. Fee is something you pay, and so there's no credit. All right, the lease options don't fall under Dodd-Frank jurisdiction. Well, technically they do not, right? Technically they do not. But the way these courses are providing you contracts and telling you to do them, yes, they do, because all you're doing is creating an owner finance deal with the title at the very top is lease and option, right? Oh, and this is the biggest one. You can use a simple one-page lease option agreement. Never, ever do this. There's only one reason to ever do it. There's only one reason I ever did it, and you need to understand what it is, okay? I did this back in 2008. We would have the seller, for lack of a better term, the sellers, the landlord optionor sign a simple one-page lease option agreement that went through all the terms that we talked about, okay? And the reason that we did that, it was not to be able to use that document, okay? Because that document is never going to hold up in court. I don't care what anybody tells you. Not going to hold up. Let me qualify that. If you run into somebody that knows what they're doing, it's never going to hold up in court, okay? Because now you've got commingled agreements all on one single page. It's very clear what the intent is, and it's just disaster waiting to happen. The only time that you would ever want to use a one-page document for a lease option agreement, and this is what we used to do, is basically to warm up the seller or warm up the landlord optionor. And so what we used to do in those scenarios, because a lot of people were not familiar with lease options when the whole housing crash came down, is we would put all the terms on paper, basically like a letter of intent. But it would be a simple one-page lease option. We would go over the monthly payment that they were going to get, what the option price was, what the option fee was, which they didn't get anyway. I got that. But nonetheless, what they were going to get from the transaction. Most of them were just happy to get a monthly payment because they were eating payments on vacant properties. So what we would do is lay it all out in front so it's not scary, one little page, here's all the terms. And once we got that executed at that point in time, then we would go with the full-blown lease option contract, okay? So we had the separate lease agreement, separate option agreement, all with the same exact terms, and now they were more comfortable. Much easier way to do it. Back then, now a lot of people, almost everybody knows what a lease option is these days. But back then, at that time, you're going back 11 years ago, most people were not really familiar with this type of contract structure and what the benefits could be. So do not think that you're going to hold up in court with a one-page lease option agreement, no matter what these people tell you, okay? All right. So here, anybody have any questions? Yes, thank you, Bill. I was sitting there thinking the life estate. We had that conversation 3 or 4 years ago. The life estate is the one time where you have the holder has a life estate, it has equitable title until death, but does not have legal title. In other words, the deed. Okay, is basically if you don't know what a life estate is. So let's say you have elderly parents. What they're going to do is, in many cases, they want to do estate planning, this kind of thing, and they want to go ahead and convey the deed to the property to whatever heir it is that they want to, or heirs they want to have it. And so, but they still want to live in the house, right? It's their house. They bought it, they paid for it, and they want to live in the house, but they want to leave it to their kids. And so what they'll do is what is called a life estate. Now, they have equitable title to the property, but they don't have legal title of the property because the deed's going to go ahead and transfer. That's the only time that either Bill or I could think of. I think he actually got me on a trick question with that once. The turmoil and the damage that can be done by somebody that knows what they're doing in court with these agreements that you guys are being provided that do all these things I'm telling you not to do. I'm just telling you, we had, if you go back on the podcast, and we did it back in, 2014, 2015, the How to Lose Everything with Lease Options. And we had Scott on there, Bill was on there, and Scott goes through his whole story about how he literally lost everything because of one improperly structured lease option deal. Lost everything, okay, because through litigation and all that, and a very aggressive state entity coming after him for what he was doing at that point. Okay, I stopped doing lease options back in 2008. I converted everything over to contract for deed or land trust or whatever for single family stuff. And you're finding out the reasons why. What happened was I was just like you, and don't take this the wrong way because it's not meant to sound condescending. I did not know, because it's not sold or told out there anyway, what the actual risks were. And where I first started to find out about this stuff was there was a guy that an investor out in California that I talked to that was heavy into lease options. I got referred to him from my next door neighbor, and he kindly told me of the horror stories that he had personally experienced in California with doing improperly structured lease option deals and conveying equitable interest. At that point in time, I'm like, what the hell are you talking about? Equitable interest on a lease option? I don't understand that, right? Because I didn't know, because it's not in these courses that they're giving you, right? And that's why it's important to understand when you're doing these things, whether you're buying somebody's course from some little Facebook celebrity or whatever. I harp on this stuff all the time. You've got to do your due diligence, okay? You've got to know, I don't care what anybody tells you, not even me, go vet the information, all right? You guys will see me do this stuff all the time where, and it's not me being a jackass, there are times of that too, but somebody will come out, and you see this all over Facebook all the time, right? You got these armchair attorneys, they're not attorneys, I'm talking about, other investors that come out and they say, they'll state as a matter of fact that this is the law in this state, blah, 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 right? And what I always come back to them with is, okay, would you please kindly provide the statute that says that, okay? And I've never once, when I asked somebody for that, ever had anybody provide it, because what they typically are doing is simply regurgitating something they got from somebody else through a course or on the internet through the gossip stuff or some real estate forum or whatever. And that's how these things typically tend to go. It's, so-and-so said this, so it's true. I'm not going to verify it. That's very dangerous. Okay. That's why I always ask people to proof up when it comes to anything related to state statutes. Okay. Because you'll hear anything and everything you want to hear on the internet. It doesn't make it true. And unfortunately, the time that you don't want to find out that it's not true is in front of the judge. All right. So hopefully that makes sense to you guys, right? I started off after the mortgage collapse. That's what the second thing. Well, sort of in conjunction, we were doing short sales and lease options simultaneously to be able to flip out to other investors with a exit strategy in place back in 2007. And so the internet and information on the internet wasn't what it is today, if that makes any sense. And so, you either learn the hard way or you get the information from somebody else who's put their hand on the stove and gotten burned. And that's what I don't want to have happen to any of you, because it's not pleasant. It's not pleasant when you think everything's all good to go, and all of a sudden you find out through litigation that you got major problems that are very, very expensive, because typically, even if you're representing yourself, litigation is very expensive, okay, from a time standpoint, from an emotional standpoint, whatever. And thank you for saying that, Bill. Bill says what you said is so spot on. I appreciate that. I'm trying to steer these people in the right direction so they don't get messed up with these stupid courses I see. And again, listen, when you guys are out there doing this stuff, make sure that you understand that it's not semantics, okay? When I harp on this stuff, and I tell you there's no such thing as a tenant buyer, when I tell you that you can't sell on a lease option, I mean, it doesn't even make sense. You don't want to do those things. You got to change your vocabulary, your vernacular, and your inner monologue, because all you're doing is broadcasting what the actual intent is. And the intent that any judge is going to understand is that you try to lure somebody into a deal under the pretense of a sale, but then, converted. And I'll tell you how it plays out for those of you who have never had this happen. How it plays out is that you're always going to be in the eyes of the court, the other attorney, the judge, the expert, okay? Even though, caveat emptor, let the buyer beware, all that stuff, you're always going to be perceived as the expert, okay? And the tenant is always going to be perceived as the victim, okay? Unless you've dotted your I's and crossed your T's and all that stuff and not done these things that we're talking about, okay? But that's the way it's always going to come across. So you want to make sure, and this is what I do, unfortunately, once you've been in real estate long enough, or hell, just business in general, I over document literally everything. That's why all my phone calls are recorded. Okay, when you call in, it lets you know up front, hey, call's being recorded, because it's a beautiful lie detector when people start lying, which they do. People get what's called revisionist history. It's gotten so bad. Those of you that actually close in title companies and with attorneys can confirm this if you've experienced this. It's gotten so bad that I've seen, attorney after attorney after attorney video record their closings because they don't want the liability either of somebody being sour grapes on the backside and then trying to litigate against them for their E&O or D&O insurance, or just trying to, sue them for malpractice or whatever. They don't want the problems. They don't want the problems with, their title insurers, any of those things. And so they've gotten to the point now, because people will blatantly lie, that they actually video record closings. Okay. And to me, that's exactly what I would do too. Then there's no question who said what and what the understanding was, right? And just absolute genius. So I over document everything all the way, backwards, forwards, upside down, phone calls recorded, the whole 9 yards, so that we have an actual documented record of what was said, what was promised, what the intent was, etc. And it's a couple extra steps that'll save all of you guys a lot of heartache. All right. But unless anybody has any other questions, I want you guys to go out there and have a great, fantastic day. Jerry says I'd rather pull my own teeth than rot in a courtroom, for sure. Guys, let me explain this to you. If you guys don't already know this, you always want to do everything humanly possible to stay out of a courtroom, because as right as you may think you are, okay, there are other variables in there. People think, and I have to cover this stuff all the time, there's a misconception for those of you who have not had, considerable experience in court, misconception that politicians and state legislators and Congress writes the law. Okay, this is not true. Okay, you may think it's true, you may argue, but yes, they do. They draft it, they approve it, it gets signed in by the governor, or the president, or whoever it is, blah blah blah. Well, my friends, here's how it really works in reality. What they're drafting are guidelines. Okay, person that writes the law is the judge in the courtroom that you're in, and he writes it the moment that you're in there. Because if everything was black and white and, right and wrong, and the law was the law, there would be no need for attorneys or judges. Okay? We wouldn't need a court system at all, but that's not the way things are set up. Okay? So he has to make a decision based on whatever it is that you're going to present to him, and your position may or may not be what he agrees that it is correct, despite the fact that it's the law. Okay. So if you guys, I don't know if you guys have ever dealt with this stuff before, but have anybody ever dealt with attorneys? Let me give you an example. This is one of the reasons why I get frustrated with people sometimes, because they make the mistake of doing things like putting attorneys on pedestals. Okay. Like, because somebody went to law school, there's somehow now this, other, idolized entity that is omnipotent, omnipresent, all-knowing, whatever it is, and they can't be questioned. They couldn't possibly be wrong because, well, they're an attorney and you're not, right? Don't buy into that for a second, people. Okay, not for a second, because I don't. I make the attorneys proof up too with the statutes and anything else. And like when we had our owner finance contracts drafted, they were drafted by a real estate litigator in Marietta, Georgia, who was also an investor that I did deals with. Okay, and when I had him do that, I'm like, look, what we're going through here is we had, and I'll give you an example in that contract that we have, contract for deed that was put together. It's set up because I want to avoid foreclosure too. Obviously, everybody wants to avoid foreclosure, right? So if you're not doing a land trust where you can avoid it, and you're doing a contract for deed or a land contract or whatever, how do you avoid foreclosure? Well, the state statutes are going to tell you that you can't, right? Most of them. They're going to tell you that you're going to have to foreclose. Well, at the time that we were putting stuff together, I told him, look, I'd rather, we've been doing these things on lease options. I'd really rather do them as an owner finance deal, on a contract for deed, but I don't want to have to go through the expense and time of eating payments and having litigation expense to foreclose and then to evict, which is what you have to do on, typically theoretically what you have to do on contract for deed, right? So he says, well, here's what we can do. We can put 2 clauses in the contract. He says, and you need to understand this, is we can contract for anything that is legal to contract for, meaning we cannot contract to sell cocaine because that's not legal, but we can contract for anything that is legal to contract for. So I said, okay, like, tell me what you mean. He's like, we can put 2 clauses in there. One will be what's called a triggering event clause, and the other will be called a conversion clause, okay? The triggering event is a breach of contract or specific performance or defaulted payment, okay? That's the triggering event. The conversion clause then takes and converts the contract from a contract for deed, okay, to a straight tenancy agreement with all loss of rights in the contract for deed upon breach of contract and or default. So we can avoid foreclosure and move right into an eviction on a contract for deed. And I said, Michael, you know what? That sounds absolutely fantastic. I love it. But if I'm going to pay for it, this is what I need you to do. Okay. I said, this will sell like hell, right? What I need you to do is I need you to back it up, and I want a letter of opinion on your letterhead showing what the state statutes are that are in support of your theory, because that's all it is. Anytime, or let me rephrase it, your opinion. All attorneys give you is opinion, okay? You guys don't know that. That's all they're giving you is an opinion. And 50% of attorneys are proven wrong in every courtroom in America every single day, but you still get to pay for them. Right. So understand, they're not infallible. They're not all knowing, whatever. So I had him put this thing on his letterhead, the letter of opinion, citing, okay, here's what we're doing. Here's why we're doing it. Here are the state statutes in support of that. And let me rephrase that. And the case law in support of that. So not only we have the statutes, we also have the supported case law that supported his opinion that in the event of a default, we could move right into an eviction on an owner finance deal. Okay, which is what you're looking for. And, thankfully, we have never had to test it, because when you're dealing with owner finance deals, you're dealing with people that want to buy a home, they want to own a home, and once they have the ability to do that and equitable title, depending on how you do it, sometimes they have legal title too, they're a lot more invested in the property than somebody who feels like a tenant, if that makes any sense, okay? So that's what we did, and it's worked out exceptionally well. Like I said, thankfully we haven't had to test it in court. I don't want to test it in court, obviously for all the reasons that we just covered. But nonetheless, that's the way that things were put together back in 2000, at the end of 2008, when I totally shifted away from lease options. Once I understood the equitable interest argument, how it was being used on lease options at that time, and it's been straight owner finance stuff since that point. From late 2008, because it's just not worth the risk of the headaches, unless it's a legitimate deal. I mean, unless it's a legitimate lease option deal, which I'm happy to do that. But keep in mind, the intent of all parties is going to be well defined in black and white. Okay, so there can't be any confusion. For those of you who don't know, haven't ever heard this expression before, there's an expression in real estate investing or in just real estate sales. It goes, buyers are liars and sellers are non-truth tellers. And so it's imperative to make sure that you have everything documented, okay? There cannot be, there's no room for any confusion or lack of clarification, okay? So that's why we go to the links that we go through, because we had, been in court and dealt with some of the stuff in the past. And that's why I get so frustrated watching you guys get sold this bill of goods on how to do these things and how to do them incorrectly. It's just like the wholesalers, like the contracts that you guys are buying from these guys are telling you, the seller grants the buyer the ability to market the property, right? And put it in MLS. And no, the seller cannot grant you anything in a contract that circumvents licensing law. Okay, they can't grant you the right. What they can do is convey equitable interest in the property itself. Okay, not the contract, but in the property, giving you a legal ability to market the property. But these stupid marketing clauses these guys have in these things where, seller grants buyer, permission to market the home, blah 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 blah, whatever. Seller can't do that. Okay, you guys don't know that. Seller cannot do that. Okay. He doesn't magically just have some magic wand that allows him to allow you to circumvent licensing law. But that's in these contracts that you guys get sold. I've seen it time and time and time again. Thank you for attending. Hope it was beneficial, and have a fantastic day.
Thank you for listening to the Virtual Real Estate Investor Podcast with Vincent Polisi. If you found any value in this podcast, please use our Give to Get method and take a moment to give us a 5-star rating in iTunes and your favorite podcast service, so we can keep giving you excellent episodes of real content you can use to profit today.